You sued your doctor for medical malpractice, claiming that he was careless, causing you harm and injury. During the course of your lawsuit, the defense wants to know how much money you were earning for the years leading up to this doctor's carelessness. Do you have to answer those questions? Can the defense attorney actually ask you those questions, and do you have to answer them? You want to know the answer? Come join me on this walk through the neighborhood as I share with you the answers to those questions. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, you sued your doctor for medical malpractice, claiming that he was careless and that his carelessness caused you harm and injury. A doctor, an expert, has confirmed and reviewed all of your records that yes, your doctor violated the basic standards of medical care, causing you harm and injury, and that your injuries are significant and permanent. Now, during the course of your lawsuit, the defense attorney who represents the doctor whom you have sued will have an opportunity to question you, to learn information about what you know, about the claims that you are making, and what problems and damages you have now. That's known as a pretrial deposition. Now, a deposition is just a fancy word that means it's a question and answer session. And that session takes place in our office, in our conference room. Now, there are two important differences between giving testimony in our office and giving testimony at trial. When you give testimony during this pretrial session, now, there's no judge in the room and there's no jury in the room. So you might be thinking, okay, what's the big deal? It's an informal setting. You go ahead and answer questions by the defense attorney. Let me share this with you in case you don't know. When you give the answers to the questions that are raised by the defense attorney, you have sworn to tell the truth. The answers that you give and the questions that you are asked are recorded by a stenographer, a court stenographer. And then that information gets transcribed into a booklet. And now that booklet represents your sworn testimony. And the answers that you have given carry the same exact weight as if you are testifying at the time of trial. So even though this takes place in an informal setting in our office, the answers that you give carry the same exact weight as if you are testifying at trial. So if you were to go ahead and contradict yourself at the time of trial compared to what you have answered and is recorded in this transcript, now that information can be used against you to show that you have contradicted yourself. So it is critically important that even though there's no judge in the room, even though there's no jury in the room, the answers represent your sworn testimony and carry the same exact weight as if you are testifying at trial. Okay, so now let's get back to the question I raised earlier. Can the defense attorney go ahead and ask you questions about how much money you were earning in the years leading up to the malpractice? And the answer is, if you have brought a claim that you have lost income as a result of this doctor's carelessness and your injuries have prevented you from working or working to your full capacity, then the answer is yes. The defense attorney would be well within their right to go ahead and ask you questions about how much you were earning in each of the 3 years leading up to the dates of the malpractice. That would be appropriate. So does that also mean that you have to answer those questions? If you have brought a claim for lost earnings or lost earning capacity, then the answer is yes, you must answer those questions. They are going to ask you how much you were earning in year 1, in year 2, in year 3. Why is that important? Because they will want to know, as a result of your injuries, tell us, have you been able to go back to work? How much income you lost for the couple of years since this happened up until the time that you're now being questioned? And what about into the future? Are you going to be able to return to work? Will you be able to perform your job duties and responsibilities in the same exact way you were doing before? Are your job duties going to be limited? Is your income going to be reduced? All because now you are no longer able to do the type of work you did before or in the same capacity. So in that regard, the defense is fully within their right to go ahead and ask you about how much money you are earning and how much money you are able to earn now. Now, there's a little distinction you should know about. If you were self-employed, the defense will have every right to ask you to provide copies of your tax returns. Because although they asked you the question about how much money you were earning, they will not rely on your statement that you were earning, let's say, $100,000 a year. They want to see proof. And the proof that you're going to show them that you have to turn over will be your tax returns if you are self-employed. If you work for a company, you will have received a W-2 form. In that instance, the defense will not be able to obtain your tax returns. Instead, they will be able to receive your W-2 form. So why do I share this quick information with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases, these accident cases, and even these wrongful death cases here in New York. You know, I realize you're likely watching this video because you saw the beautiful scenery and you wanted to come see where I was walking. No, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter happened here in New York and you have not yet started a lawsuit and have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.